Hello, everyone. I'm your host, Miles, and this is XRAISED, where knowledge meets inspiration in the intricate dance of industry evolution. This is a milestone because we're on our 50th episode with MIAI Law, and this feels like the perfect moment to talk about ideas that challenge, question, and push systems forward. Since it's a special day, we have two extraordinary thinkers, so we can talk about why dissent still matters, how it might be more relevant now than ever, and how we make better decisions, whether you're in law, business, or building technology that shapes both. We have here for the very first time, I'm so excited, the Honorable Michael Kirby, an international jurist, educator, former Justice of the High Court of Australia, one of the most respected legal thinkers globally, and the author of a newly released book, which is a powerful collection of his speeches and papers spanning decades of legal and social change. And of course, we have Laina Chan, my favorite award-winning barrister, CEO, and founder of My AI Law, and one of the most influential voices right now in legal tech, ethics, and AI-driven research. Hello, Justice Kirby. How are you? Welcome to our community.
Hello, Miles. Thank you for having me. We're
Thank you.
all ready to go.
I know. Thank you. It's an honor to have you. And hi, Lena. Thank you for letting me have this opportunity with you and Justice Kirby. I mean, this is a big day for me and big day for our audience. So, our topic today sits under one idea, architecture of dissent. And please let me start this with a question for Justice Kirby. Looking at what you've brought together in your new book entitled Law, Justice, and Other Challenges, what feels most changed in how we talk about law and justice today, and what perhaps surprisingly feels almost unchanged?
Well, there are many things that have changed, and many of them have changed for the better. For example, the treatment of minorities, the prejudice against women, prejudice against indigenous people, people of different skin color than yourself, prejudice against LGBT minorities, and so on. So that has changed gradually. In some countries, it hasn't changed much at all. But then there's technology and the changes that it brings to society. And to some extent, the technology stimulates the change in attitudes to minorities because it spreads the knowledge of our world, access to the internet, access to artificial intelligence and chat GPT and other devices. So the combination of those radical changes and a society and a world in a process of change is a very stimulating moment to be alive. And it's our duty as human beings to make the most of it and make sure that it serves the benefits of humanity on our little blue planet.
Mhm. Right. And thanks for that kickoff, Justice Kirby. The topics around gender, as you said, race, have been evolving indeed, but the tensions don't really disappear. And as someone coming from the business media, it's striking how familiar that sounds. I mean, different tools, yet same debates. And in the overview of your book, it's clear that many of these themes keep resurfacing over time. From your perspective, is that repetition a sign of unfinished work in the institutions, or is it simply the nature of justice in an evolving society?
It's a bit of both. I think the fact that you make progress can then stimulate a reaction and a pushback. And I think we're seeing that in the world today with developments in politics, developments in attitudes towards the United Nations, developments in attitudes to an area of the United Nations that generally had very broad consensus, beneficially broad consensus, such as the World Health Organization and access to essential healthcare. But to some extent, with that pushback has come a reversion in some countries and in some places and with some themes to attitudes of the past. And that is the source of fear and concern. So we're living at a time of existential change, and some of those changes will bring great advances for human beings, but others will bring threats and dangers. And our obligation as thinking human beings is to use the technology for the benefit of human beings and to ensure that we don't let things happen through human intervention or through technology that endanger our species in this planet. As far as we know, we are the only rational and thinking and feeling and communicating species in the universe. It seems weird, and the mighty universe with all of its stars and planets, that we should be the only ones who have thinking minds, but no one has yet found us anyone else who's at our stage of evolution. And that's why this is an important moment. We are poised either to make great progress or to endanger the survival of our species.
Mm-hmm. Well, interesting framing, Justice Kirby. Unfinished work versus ongoing conversation. It's like a system that's constantly being stress tested, I think. So now, when disagreement becomes uncomfortable or maybe even unpopular, what helps you distinguish dissent that strengthens the law from dissent that simply unsettles it?
Well, dissent is simply expressing a different viewpoint. Dissent in judicial decisions is not a universal feature in the law. In countries of the civil law tradition, which would include Mexico and countries of Europe, it is not a feature. And indeed, if you speak to judges in those countries, they generally resist the idea of dissent, and they have to either ignore differences or they have to bury it in suggested concurrence but actual disagreement. Whereas in the systems of the common law, which countries like the United States, Australia, Canada, UK, and so on, the right to dissent has been an important feature historically of the judiciary. And the judges, you may agree with them or disagree with them, are bound in multi member courts to express their truthful conclusion and to give reasons for them. And in that sense, the dissent is an ingredient in the mix that will lead on to the further evolution of the law and the development of new ideas about justice
Mhm.
and new ideas about minorities. And that is the way in common law countries, particularly, but basically in all systems of law, we get progress in the law. And progress is very important in law as in technology. And our duty is to make the progress, keep the good that is in the bad and in the past, but make progress. And where that requires dissenting voices to be raised to point the way to the future, that's an important aspect of the judicial function, at least in the common law countries. And it's an aspect that I always took very seriously in my judicial life.
Mhm. And I think that's a very useful filter, and that lands from the outside. Dissent can look, as I would always say, disruptive. But what you're describing, Justice Kirby, feels more like a disciplined disagreement, if I'm making sense, not noise for the sake of noise. And long before AI become a boardroom topic, I learned you wrote about technology and the law back in the 80s. Lena mentioned to me that Bryden Wang has described you as consistently being at the forefront of technological thinking. So, looking back now, what did you sense early on that others perhaps weren't seeing yet, and what still worries you or maybe excites you about how AI is being adapted today?
Well, first of all, you have to know some extra facts. And in my life, when I was at school, when I was a little boy growing up, I discovered that I was gay. And that was a very big discovery, and in many ways, a bad discovery at the time that I made it. But that made me very conscious of the fact that there were other minorities. For example, in Australia, the minority of the indigenous people who were disadvantaged in many ways, particularly in criminal law and in imprisonment. And that is a matter which was mentioned earlier this morning when a new judge was sworn into office, and he pointed to the very high levels, even now, of the imprisonment of Aboriginal people in Australia. Very high levels. Indeed, they're possibly the highest level of any racial group in the world in my quiet, peaceful, well-governed country. So discovering your own subjection to injustice should make you conscious of the injustice of others, injustice to women, injustice to people of different skin color, injustice to people of indigenous status, LGBT, people with disabilities, refugees, migrants, and others. All of these minorities, women are not a minority, but all of these groups in society have particular burdens. And it's no good being a gay person who is always rabbiting on about gay rights and ignoring completely women's rights or the rights of racial minorities. You've got to learn the common problem which exists in disparagement and disadvantage of people who are minorities or people who are disadvantaged by tradition, sometimes by religion, sometimes by technology itself. For example, in Australia, if I go to a conference of computerists, if I go to a conference about the World Wide Web or the new developments in technology, it's always surprising to me that the overwhelming majority of the participants are men. Now, what is it about the Y chromosome that means men have an advantage in this area? Is it a genetic advantage? That seems very unlikely. Or is it an advantage in the way education is delivered in our countries, which has meant that women have not had the same advantages in mathematics, in science, and in topics of this kind that will put them to the forefront in areas of technology that involve uh, digital space? So that's something I think we've got to think about. And if it is a problem, then we're losing half the population contributing to our progress. And that is something we should all be concerned about, men and women, straight and gay, Aboriginal and settlers. Everyone has a stake in ensuring human rights, universal human rights, and equality and justice for all.
Mhm. Equality indeed. And it's rare to hear someone speak about these technologies before the market even had language for it. And I appreciate you sharing that, Justice Kirby, because this moment is less of a sudden revolution and more of a long unfolding curve. So now let's turn this to you, Laina, drawing from your own career. When have you seen dissent or an unfashionable argument actually change the outcome of a case or a legal position?
I actually have one example. I was acting pro bono for some retirees who had been I think, evicted from their retirement, or they had left their retirement village, or the mother had died, and they couldn't get the retirement village, I think, had then gone under. And there was a question of priorities as to whether they would be able to recover any money at all that the mother had paid into the retirement village. And it was before the president, the now president of the Court of Appeal, but she was the chief judge in equity then. And the accepted argument when I first started my submissions was that my client would not be able to recover any money at all because everyone in the courtroom had a preconceived idea as to how the priority rules worked. And then I was trying to make my point, and in the beginning, Justice Ward, wasn't with me because she just assumed that the rules worked a certain way. But eventually I got my point across to her. And like now when I talk to her about it, she goes, like the moment the penny dropped, that she realized that my argument was actually the correct way to construe the retirement village, the piece of legislation. And so as a result of that, she accepted. And she accepted my argument, which she admits that when I first started making my submissions, it was pushing, uphill. It was just a really uphill battle. But then at the end of the day, I won for my clients, and they were able to get the contribution that the mother had made to the retirement village. So that was really satisfying because it was completely unexpected. There were like 8 or 10 parties in the courtroom, and nobody expected that outcome. And obviously you can really tell when the bench is pushing against you. But ultimately she listened, and then we triumphed. It was very satisfying.
Isn't that interesting? The listening judge, the
Yes.
judge listening to argument, keeping their mind open,
Yes.
aware of the authority of the past, but always looking for the justice of the past. And the
Yes.
biggest example of that, I think you'd agree, Laina, is the Mabo decision.
Yeah.
If the old law had been applied, the indigenous people would have always and forever have been denied access to their traditional lands. But then in 1992, a case before I joined the High Court of Australia went to the High Court. I was then with you back in the Court of Appeal, and it challenged the Mabo, in the Mabo decision, it challenged the notion that the Indigenous people had no claim to their traditional land, and it ultimately reversed that, and that became a tremendously important change in principle. And
Yes.
that would not have been done by a machine. I think it's important in our context to
Yeah.
make the point it's unlikely that that would have come out of Chat GPT. That came out of human consciousness.
It wouldn't have come out of ChatGPT, but I was actually discussing this with Bryden yesterday as I was walking home because he suggested that you might actually bring up Marbo today, and I've heard you make your point that you don't think that the machine could have done this. But I obviously, as a result of developing this product, I know the constraints that you can put around the machine, the language model, as to how it's allowed to reason. So if you open it up and you say you're not to just base your conclusions on precedent, but you are allowed to evolve it and you are allowed to take it to the next step, then it could have come out. But if you are basing it purely on precedent, then yes, I agree with you that Marble wouldn't have happened.
Well, of
But it's an
course,
experiment that we could run.
many, that's a very good point, and that's part of the importance of your development, to find what is the binding rule. Often it's not as broad as lawyers might have thought. Often it's quite narrow, but finding what the binding rule is, and then remembering where you are in the judicial hierarchy, you may have greater power, and indeed you may have greater responsibility, and you may have virtually unlimited responsibility to be a safety valve and to change the law where necessary. And that's an important feature of the hierarchy of courts, whether a judge has the right and the power, but every judge in our system has the entitlement, and I would suggest the obligation, to point to the fundamental injustice of a particular legal principle and to say, well, I'm bound to give effect to this, but I have to point out that this, in my respectful opinion, is an injustice. And that sends the signal and rings the bell for the appeal courts to consider this. And if the appeal courts fail to allow Parliament to reconsider it, in our legal system, that's how it works.
That's right.
Mm-hmm.
So I was talking to Brian about this, and I can do an experiment because I can loosen up the constraints, because at the moment we have very tight constraints that don't allow this kind of creativity. But I could open it up, and I can allow cross-jurisdiction analogies to be drawn, etc., to see what would happen. But that's an experiment. Maybe I should do that experiment. We can write a paper on it to see what.
Oh, it sounds a good experiment, but having sat in appeal courts, both in the Court of Appeal, the intermediate court, and then in the final court, in the High Court of Australia, I think there's something in the water of lawyers, particularly as they go up the legal ladder, that leads to a self-restraint. And they say, oh, well, that's for Parliament to change, or if I change that, I might get struck down by the higher court, or I might get criticised because I'm making instability in the legal system. And that's why it's got to be done carefully and respectfully and in a principled way, which is exactly what the High Court of Australia did. By 6 votes to 1, it was almost unanimous, 6 to 1, in the Mabo decision. That's why I mention Mabo, because it was a very big decision. I remember I was in the Court of Appeal in 1992 when that was decided. When were you in the Court of Appeal? You were there at about this time.
1994 and 1995. But we should tell Miles what the Mabo decision is.
Yeah, please.
Go ahead, Michael.
Because I'm lost here. Kind of lost. Please go ahead, Justice Kirby.
Okay, as quickly as possible. From the earliest days of the convict settlement in Australia, Australia was settled by convicts brought out from England because of the American Revolution. The American Revolution changed the rule of the 13 colonies of England in North America, and that led to the independence of the United States, and that led to the obligation of the British to find a new place to send all their convicts. And they remembered the exploration about 20 years earlier by Captain Cook of the South Pacific, and his description of this very large temperate land, and that it seemed to be substantially unoccupied, and therefore they took that and they sent out British forces with convicts to set up a colony, a convict colony, and that's what began the story of Australia. But they did find that there were Indigenous people there, and they had lived there for 30 or 40 or 50,000 years, and they had their own system of law and rules, and the question was, could they come to a court of the convicts and the British and say, well, under my law, I am entitled to have exclusive possession of my land, and you colonists have got to respect that and not intrude without our permission. And unfortunately, the law developed to say, no, that is not part of the law. You cannot challenge the the position of the Crown being the ultimate owner of all land, and therefore that includes Aboriginal land, and therefore Aboriginals have got no right to their own land, and that remained the position ultimately until the Mabo decision, when by a vote of 6 of the justices to 1, the High Court of Australia is made up of 7 justices, 6 to 1, the justices said, well, this was something that was said back in the very early 19th century, but it isn't a law that is suitable for our time. And therefore, if you can have the principle of recognising a native title of the indigenous people, then the general law will recognise that. And that was a very big decision for a court to make. It had not been made for 200 years by parliaments, elected parliaments, but it was made by a court because the court said, if there's one principle of the world today, it is that you cannot deny people their rights under the law by reference to their race. And that was a very important principle embraced by the majority in the High Court, upheld in the Mabo decision, applied in that decision, and applied in many other decisions since then in relation to First Nations people, Indigenous people in Australia.
Wow, what a breakthrough. I have to read more about that. Thank you for the quick overview, Justice Kirby. I really appreciate it. And going back to Lena's example, I think it's a reminder, good reminder, that progress doesn't always come from having the loudest argument. In this case, it comes from having the right one. And I guess even when it's inconvenient. But how do competing or minority arguments, Lena, change the quality of legal judgment? And how does that way of thinking shape how MIAI Law approaches legal research?
Well, we're actually constrained by what the ratio, what the actual principle of the case is, and what the binding rule in each case is. And that's how we actually deal with all our research. We look at all the binding rules, and then we look to see what the correct relevant rules might be to apply to the factual scenario that a user might put to MIAI Law. So we don't actually, we capture what the minority decisions are, but we don't actually rely upon them in deciding or in preparing the answer to the research question. But the minority decisions are really important, more so in your research when you're looking at the doctrinal development of the law over time, because those minority decisions can one day become majority decisions. So you can track the development of the law that way. But I think it is important in the way that Michael says, that I remember reading a book by Lord Denning, who's an English judge. I loved his judgments. And in the book, I think he was, when he was, I think in the Court of Appeal, that right, Judge, he was always the dissenter. And then he went up, I think for a short time, to the House of Lords, and he was continued to be a dissenter. But in his book, he said he really didn't like it, because at least when he was a minority judgment in the Court of Appeal, when the decision was appealed to the High Court, at least his minority decision helped inform the opposing arguments, issues that the House of Lords might consider in deciding, whether the law should evolve. But he said that when he was a dissenter in I think it was the House of Lords, his judgment went nowhere. And so I think he actually stepped back down to the Court of Appeal. And I think that's why dissenting judgments are so important, because they give you the opposite point of view and help with the development of the law. Not so much in MIAI Law, but in the continuing development of jurisprudence and the rule of law.
This is where it clicks for me, really clicks for me, because it's more like giving judgment a bigger, better lead room to operate in. I mean, rather than AI replacing judgment. And as AI becomes part of everyday legal decision making, how do you think about preserving nuance, contestability, and multiple lines of reasoning rather than prioritizing speed or certainty alone?
Well, we did that. So when we were, as I've shown Michael how we can extract the rule in each case and called the ratio. When we're dealing with high court cases and we're extracting the rule, we're very, very careful to extract the rule that each particular judge has applied in making the finding, and then we then make sure that we're capturing which of those rules actually represent the majority view, and then obviously that becomes the rule of the case itself. But we're very careful when we're analyzing the case that we extract all those nuances and we don't collapse all of the decisions of the 7 High Court justices into one. We're very careful to make sure that we extract exactly what it is that particular judge said, and and how, and that particular judge's reasoning and how it goes towards the conclusion that that judge ultimately makes in the decision. So in that way we capture it, and at least in our research reports we will, that kind of information is revealed in our research report.
When I saw your development and the way it could very quickly identify the rule of the case, I thought this is just wonderful. It's wonderful. But I'm now going to make a commercial suggestion for you, because I think it would be a good idea if, in addition to finding the rule in the case, you had a pop-up that said possible future developments, and then drawing upon previous decisions and reasoning in the instant decision, saying this is a line of development that the law might develop. And I think that would be a contribution of your technology. You could turn off the pop-up if you don't want to see that, or if you're advising very commercial people who only want to know what the law is and what the rule is, then your answer may be one thing. Well, I'll leave it to you to take it further, but I've given Laina a really good commercial suggestion, and I think that should be put a pop-up with future lines or something like that. And if you don't want it, you can turn that facility off. But I think that would be a way of higher judges to have something that stimulates their mind and authorizes their mind to think past the ruling in the particular case.
It would require me, Judge, to do that experiment that I was talking about earlier in our podcast. I would have to relax the constraints that I have at the moment to prevent it from doing that, and then to put in rules as to what kind of creativity the model can engage in and where it can get these other lines of development from. But
but you're a very bright cookie, and you always were back in the Court of Appeal days. You're even brighter now because you've got the technological aid, and you can develop something. There's no technological problem.
No, I can do it. It's a different feature. I would call it policy research or something. I don't know. I'll call it a thing, but it's a different. It has to have a different, because people have to realize when they use that feature, it's going to allow the system to be more creative.
Yes, I agree. They've got to know the difference. Otherwise, they'll say Laina Chan's technology is hallucinating, and we don't want that.
That's right.
You're stubborn, as she would always say.
No hallucination, no hallucination.
Yeah, that's right. Has lost its mind.
Well, I like how this is going, designing systems that surface alternatives instead of prematurely collapsing to one correct answer. So I think that suggestion would help. There's always a comfort in knowing the goal is to have the best or at least better questions. And I want to ask you both this: where do you draw the line between AI as a tool that assists judgment and AI as something that begins to exercise authority?
Well, I think as long as you keep those differentiations clear, both in your own mind and in the technology that you're offering to the market, then there is no problem. Those who want to explore ideas that have been let loose by the minority reasoning or by a minority thought in a majority judge's reasoning, if you make the distinction clear, then it can be horses for courses. You can use the binding rule for most reasoning in a legal context, but then if you're before a court that has authority to stretch the law, as the High Court of Australia did in the Mabo decision, then it would be a useful thing to have pointers to directions in which you could stretch it and refer to earlier suggestions, ideas, or corrections that have been proposed by earlier judges.
Miles, we can't hear you.
Would you like to add something to that, Laina?
Yes, the only thing I would add, that is true, but it's also true that we don't always know. We design a system and we deliver it, but we can't always anticipate the use cases that the user is going to put it to. So we don't know. We design it to be ethical. I design it to be ethical, that I only allow lawyers to use it, but you don't really know what's going on in their heads and what other uses that they might put to it, that because we can't envisage every single use case they might come up with. So, I mean, we say that we want it to be always a human in the loop and the human to always verify the answers. But then yesterday I was in a demo and there was the suggestion that a product would be offered without human verification openly, and that using our MIAI Law, they would design a product and sell it to clients, etc., openly admitting that it's not been verified by a human, and that if they want it verified by a human, then it's going to cost more. So that wasn't how I designed the system, because the system was designed that it always had to be checked by a human being. Right? But I can't stop them. All I can say is I recommend that you check everything, because I can't guarantee the accuracy of everything. But but then they're saying we're going to openly, I mean, it's an idea that you're going to openly declare it as not be checked by a human. And so I know.
Well, product architecture.
But it's a good idea to have, at least in some areas, a requirement to check with a human.
Yes.
For example, in the next week, the New START Treaty of the United States and the Soviet Union, now the Russian Federation, expires. And that's the only living, continuing treaty that controls the use of nuclear weapons that those two great powers with nuclear weapons have agreed to. That is about to expire. Everybody's warned about this, but nothing's being done. And it may well expire. And at that point, we don't want to turn over to machines or to AI the making of decisions relating to the use of nuclear weapons. We
100%.
don't want it. We certainly, and there will be a sort of hierarchy, there will be a pyramid of decisions that we want to preserve and protect in human hands. Because a human being wants to go home and put their slippers under the bed, whereas a machine doesn't want to do that. The machine is just going to apply the rule that you program it with. And that's why there will be some decisions that you have to differentiate what is the binding rule, and then you have to facilitate, or at least make possible, a human decision that takes you an extra step.
That's
because
right.
the Mabo case proves that sometimes the binding rule is just wrong, or the binding rule is unfair, or the binding rule is laid down in earlier generations when things were different, or when religious opinions prevailed, or other matters of that kind prevailed. So I think that we shouldn't think that every change in the law is good, and
Mm.
we shouldn't think that everything can be achieved that we want, and some things that we want for the moment will not be desirable, and you've got to have a human interposition so
Yeah.
that the matter is ultimately left to a human being.
Mhm.
No, I 100% agree because I heard that America is incorporating Grok AI, Elon Musk's AI, into all of their defense systems. And I really hope that they have a human in the loop there and they're not allowing the machine to
Decide.
make
Well,
automated decisions, especially when it's all being incorporated into their defense systems.
Mhm.
Because we don't completely understand. The reason why it takes me so long to develop a feature is that I don't always know that the how the AI is going to behave. And it's very slippery. If the moment you don't have a constraint in the model, it realizes there's not a constraint and it slips through it. But we don't really know that it's going to do that until obviously after it's done that, then I can see it. And I think that I'm not sure if everyone fully understands how an AI, a language model, has been trained. We know that it's been trained to always answer, to be useful, and it hasn't been trained to be particularly accurate, but it's been trained to be useful and to always answer. And then it's got all these other behaviors that it has taken on to allow it to deliver its mission of always answering and always being useful. So it's a bit scary that
Yes.
Grok's AI is being incorporated into the US defense systems.
Hmm. Well, that
and
tension
there would
is
there
like,
there may be similar developments in the Russian Federation. And one has only to look, for example, to the bombing and rockets and missiles and drones that are being used on both sides in the Russia-Ukrainian war to see how dangerous modern weapons are, and if they are controlled by an artificial intelligence machine set to a particular program that is going to be useful. Well, what is useful? Is useful going to be to save Russian lives, or is useful going to be for a particular military
Yes,
objective or for humanity?
that's right. It's pretty scary.
it is. I'm speechless, but that tension feels like the heart of this entire conversation. Tools are really powerful. You know that, Lena. You know that, Justice Kirby. But authority carries responsibility, big responsibility, and that distinction really matters. And I think this is a perfect place to land. This brings us right back to the idea that dissent is a safeguard rather than defiance. It's how
Yeah.
systems stay honest. So, Justice Kirby, congratulations on the release of your book, Law, Justice, and Other
Sure.
Challenges. And Lena, congratulations on our 50th episodes together. It's always a pleasure doing this with you. Thank you so much for being here, for joining me. It's an honor.
It's an honor
It's
to
a
be
pleasure.
here.
Thank you. Oh,
It's my
I
therapy. You're
might
my
cry.
weekly therapy.
I might cry, and it's Justice Kirby's fault. Just kidding.
You don't understand how excited she was, Judge. She just kept saying, "Oh my gosh!" She asked me so many questions. Oh my God, this is the most exciting thing. I've never interviewed such a what is it deal or such a incredible person before. Oh my God, I'm so nervous. Oh my God, I'm so excited. She's just
I'm
so
sorry.
funny.
And I can't contain it
Yeah,
until now. I
but Lena, you're not nervous at all. And looking at your diamonds around your neck, you
I
are a
know.
very successful lawyer, and you don't need to be frightened of anyone. And I'd like to know where you got all those diamonds. And
Oh no, there's a story to this. So I was at the British Museum in June, and there's a piece there that's from a Kundan piece, like exactly like this. And then I was like, oh my God, like it's just so beautiful. So I went to a craftsman, artisan in Rajasthan, and he replicated for me. It's only silver and diamond slices, and he replicated it. It's silver with gold plate, and today's the first day I'm wearing it. And obviously, because I didn't want to pay like 50,000 pounds to get it made in gold. He just made it in silver and then gold plated it, and then put the diamond slices and little pearls and stuff. And so it looks far more expensive than it really is.
Well, it's how
It
you
sure
carry it.
looks good.
It does.
Oh, thank you.
Well, thank you so much again. And to our audience, it's kind of remarkable to think that the questions Justice Kirby was asking about technology, his ideas, and the law back in the 80s are now being built quite literally into the architecture of how MIAI Law approaches research and judgment today. And I hope that landed for everyone watching or listening to our podcast. If this conversation sparked your curiosity, I'm sure it did. We've put all the links in the description, Justice Kirby's book, of course, and MIAI Law, so you can explore both in your own time. Thanks,
Can I
everyone.
can I
Yes,
just make one last comment?
yes, please. Sure.
The reason why my research is so thorough and I go always back to the beginning of the source is because I worked for Justice Kirby and Justice Clark. And because of the research that I did for both of them, and how for when the research I did, it wasn't that you had to do it really quickly, but you had to make sure you were really thorough and trace everything back to the beginning, which is all that I learned right from the beginning of my career working for these two judges. And then when I was a solicitor, I remember the partner saying, Laina, you do not have to reinvent the wheel. You do not have to read the cases. Just go to the textbook and see what the textbook says about what the case means or what the law means. And that didn't really work for me. But at least when I became a barrister, that was more important. But of course, always constrained by how much money the client is willing to pay you and time. But now in building this product, that's where all that learning came from, that now I can make sure we're as thorough as we need to be, which is very exciting.
I hope I have shares in this company.
It's not too late, I think. Justice Kirby.
No,
Look at Lena.
not at all. Okay.
Well, thank you so much. Thanks, everyone. I hope you
Okay.
check out more of our episodes soon. This has been your host, Miles. Stay focused, driven, and inspired with X-Raised.